books, vultures, etc., etc. And when you ask, please bring your facts, they say everybody knows. They wouldn't have the facts. So, but we will not be daunted. We'll do that which we think is in the best interest of our profession and in the best interest of our nation.
There's a major issue that the public has not averted themselves to, and that is, in the event that a complaint has no basis or it's a frivolous complaint, what happens? The complaint is simply dismissed. The lawyer has incurred a lot of costs, maybe for over a year, coming here. There is no provision for the deposit of cost in the event that it is actually found that the proceedings are actually frivolous. And I think that is unfair. Anybody that is going to lay a complaint against a lawyer and insist on prosecution must be made to pay a reasonable amount as deposit in case it turns out that such a prosecution was actually frivolous or malicious.
Back at the sitting, the committee listens to testimonies from some witnesses on matters pending before it. In an interview with Law Weekly, the chairman says with the work of the LPDC, lawyers are taking issues of discipline more seriously.
The work of the committee is getting known. When we started, the hall used to be almost empty. Lawyers did not pay very serious attention to the issue of discipline. But now we find that we meet or we sit every 1 week, every month. And for the 4 days that we sit, or 5, as you can see for yourself, the attendance is usually very high. And that has triggered more complaints against our colleagues. And so therefore, we have issues relating to the management of the growing cases, funding, administrative work, that is service of processes. Sometimes you need coercive orders, you don't have a bailiff section, quite a number of things, and therefore we are taking those matters up with the body of benchers and with all the other authorities, and those are things that from time to time will be resolved.
The chairman of the LPDC has also made a case for the review of the rules.
See, the present rules are ripe for change. The existing rules are rules that have been in existence since 2006. And we have discovered that in between, from 2006 till date, there are certain innovations in the adjudicatory processes, some of which have been introduced by the judiciary through the practice directions. Now, those are to fast-track cases, and the committee has taken the liberty to, on an ad hoc basis, to introduce some of those reforms, like the front-loading and what to do with the witness statements on oath and the rest of it. And it has made the proceedings rather fast, but we need to have them properly spelled out. The way they are spelled out now is clear, but you need to really make very clear rules on adjudication of cases so that the cases can move rather fast.
So for members of the public who have issues, here's how to make a formal complaint.
Nigerians, we want them to approach MPA anytime they have issues with lawyers. If it has to do with professional misconduct, it is our duty of course, to deal with them. So now you do your petition, either to the branch of MBA close to you, or you write to the CGN, or you write to LPDC, or you come to MBA president or general secretary that this is my petition. But then the procedure now is that you will depose to an affidavit, go to any court or federal court, do your statement on oath to back up your claim. Then we will now reproduce that your petition with that affidavit. We will forward to that lawyer involved, the hearing lawyers. for his response, fair hearing. Within 14 days, he will put in his own response and also the post on affidavit. Now, at that point, we will now forward to our panels. We have South-South, Southeast, Northwest. So for hearing of that petition brought by anybody at all. So once you can establish that there is a professional misconduct, whether your money was siphoned, probably you give somebody work, he didn't do it, it's your right to complain. Or somebody didn't do your case well, you have the right to complain to NNBA. So at that level, they will invite you to the panel and they will hear your case. Eminent lawyers are there, SANs, among other lawyers are there to entertain your complaints. Now, if they now find a prima facie case being made out against such lawyer, it means he has to come to LPDC. Now, by Section 12 of the LPDC, such person will be punished. You can strike out his name from the roll. Of course, it could be warned. It could be suspended for certain years, among others. So that is just the procedure that we adopt. Fair hearing.